All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time and date set for our cause number CV230772, Milliman Investments LLC versus David Berrey. These proceedings are being audio and video recorded as well as live streamed. So I ask you to introduce yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to present their argument. Appellant's counsel is responsible for reserving any of that time for rebuttal should you choose. We have read the briefs. We have discussed this case in conference this morning. We are familiar with the facts. Bear that in mind during your presentation. So at this point, I would ask counsel, are you ready?
Yes, Your Honor.
Please proceed.
Judge Catani.
Oh, I keep forgetting. Judge Catani is clearly not here. He is ill, and we didn't want him to infect you or us, so he is watching online, just so you know.
Your Honors, may it please the Court, my name's Al Arpad for David Berrey, the defendant and the appellant in this matter. I'd like to reserve, 4-ish minutes for rebuttal. This is one of the oddest and messiest cases I've ever been involved with, so I don't really know where it's going to go from here. I'm going to address the merits of the easement issue, even though that's probably the most important issue that needs to ultimately get resolved toward the end of my argument, because frankly, I think this is the most obvious case of a dispute of material fact that I've seen in my entire legal career. You have a couple of fairly conclusory affidavits from people saying they used the strip. There's a strip of potential roadway that's at issue in this case, and a couple of people submitted affidavits saying they had used that for access to their property. And everybody, not just my client, submitted photos and maps showing that actually there's this road that's off the property. It's on a different property.
Yes and no, it traverses at the beginning the 30-foot strip. It goes down, and then each of the individual parcels has to traverse the 30-foot strip to access their parcel. So when you say it's on a completely different parcel, that's not entirely true, is it?
I think that's true. My client said that in the trial court briefing, and I think we said it in our briefs, that there was a crossing, at least for Ms. Coupin. There's a crossing for my client. There's not really a visible crossing for the others, but in theory, if it was going to be used as access, they would also have to cross it. That's true. Not the city of Mesa. They're at the bottom. They've got direct road access. But that's not enough to be an acceptance of a road going up and down the whole parcel. And again, we've cited the TMS Ventures case as persuasive authority because it's unpublished. But I think it's a very correct analysis. If it's going to be by use, you've got to prove the actual use. You can't prove the use of something different.
Isn't that what they did with the affidavits? They proved that they used it. I mean, you'd say it's conclusory, but it says, hey, we use this 30-foot strip.
But then you've got all of the physical evidence in the case, plus my client's testimony that, in fact, this is virgin desert terrain. I mean, you can still see Native American Hohokam footpaths out in the desert hundreds of years later, because that's what happens in the desert when you use the same path over and over again, and that's just not there. That's an issue of fact. Why isn't it there?
How long has this easement been in existence?
The original grant, the original attempted grant of fee interest to the county was in 1956, so a very long time.
Okay. And if there was any use after 1956, then it would be dedicated for public use, correct?
No. Under TMS Ventures, the use has to be as a road.
Okay, that's not controlling authority, correct?
It's not controlling authority, but
okay. So
the Pleak case doesn't apply because the Pleak case is very clear that we're dedicating an easement. The grant in our case is very clear that it's granting a fee.
all right, well, and that's not the point I was trying to get at. The point I was trying to get at is the aerial photos that were submitted don't take into account whether or not this was used at the time of the granting back in 1956. This isn't a 1962 aerial photo, is it?
No, it's not a 1962
How about a
aerial photo.
1972 aerial photo?
I don't believe well, actually, there is one in the record that claims to be a historical photo. It's in the fee application for the plaintiffs, but we don't know the exact date of that one either. But there's no evidence that there were ever two roads or that the road migrated.
So how, per se, were they to demonstrate use? They say they walk on it. They say they use it for ingress, egress. They say, you think they're conclusory affidavits, but what more were they required to show for use?
They're required to show use as a road. I mean, if they walked up and down at one time, 20 feet over from the actual road, which honestly I doubt that even happened, but if they did, that isn't acceptance of a public road. The other problems that we have in this case that make it difficult is that there are other cases going on at the same time. We have another case with the flood control district in which they argued essentially the same theory, in which the county failed to disclose that in reality this is probably county property and the result in this case may ultimately not matter. Now that's not before you in the record here, but I just want you to be aware of that there are these other cases going on, and somehow at the end of the day we have to get this all into a final form where we know where the road is and we know who owns the road so that we can deal with permitting and all kinds of other issues that have been kind of spiraling out of control since the original decision was issued in the flood control case. Mr. Milliman has said that issue preclusion should apply, but Mr. Milliman also said in his brief that the flood control district's claims in the other case, which he thinks should be preclusive, weren't against him and that there is no judgment against him. Pages 9, page 10, page 14. The flood control judgment does not address claims brought against Milliman because the flood control district did not and could not assert any claims against Milliman. I think that right there says that you shouldn't be applying issue preclusion in this case because Mr. Milliman admits that he's not the subject of the judgment and issue preclusion requires identity of parties in order to assert offensive issue preclusion particularly. Excuse me. You've also got law of the case operating in this situation because Judge Gass ruled earlier in the case that you do have to name all the defendants when you are entering a judgment and sent us back to get Polly Berrey, Mr. Berrey's wife, specifically disposed of. And he said there that Polly Berrey's not mentioned in the judgment. Polly Berrey appeared in the action, was not dismissed. That would be equally true for this judgment in the flood control case. I'll jump to attorney fees real quickly because I want to make sure that I get this in there. I think you should reverse on the merits for the reasons I've already talked about, and that would reverse the fee award pretty much automatically. But even if you were not to reverse on the merit, there are independent reasons to reverse the fee award. The Milliman parties actually admitted in their reply in the trial court on the fee application that more than $5,000 should be deducted from the fee award. The judge didn't deduct the $5,000. The judge went ahead and awarded them the amount they had originally requested. That alone is a pretty obvious error. And in fact, on appeal, the Milliman parties didn't even make an argument about the amount of the fee award. So that by itself is a clear confession of error under the standard that Judge Morse stated in his special concurrence in the very recent case of Mayberry v. Stambaugh. I think you have to reverse as to at least the amount. And I think you also have to consider whether 1103 is even applicable here.
And just to make sure that I am clear, they moved for attorney's fees under the 1103, but also under contract. Is that correct?
No, they did not do that in the trial court. They did
I thought
that.
it was stated in the complaint.
I don't think it was, Your Honor, and it certainly wasn't in the fee application of the award.
Okay, let's assume for the sake of argument that it was stated in the complaint. Are you saying that they believe they waived the contract?
If they didn't make that argument to the trial court, yes.
In the fee application?
Yes.
That it wasn't enough to preserve it by staying it in the complaint?
Yeah, and I also made a point, I believe in the reply brief, that that wouldn't be sufficient in this case because a quitclaim deed shouldn't be seen as a 50-year continuing contractual relationship that would obligate you to pay somebody's fees under contract. I know there's language out there in cases saying that a deed is a contract for those purposes, but this is a quitclaim deed, the entire point of which is to not get into a permanent relationship, either an easement dominant servient owner relationship or a relationship where you're going to be obligated to pay somebody's attorney's fees.
Isn't there a simpler explanation for why fees aren't admissible under 1103B, and that's simply because what was presented shouldn't have been signed because it wasn't the easement that ultimately is the appropriate, correct?
Yes. And again, that goes to the footnote in the Pleak case that this wasn't an appropriate request. In fact, the request is pretty far off the mark. The case has morphed so much. Mr. Milliman was actually originally arguing in his first complaint that the county owned the property. And it has turned out through evidence that the county did not disclose in the first round in the other case, which isn't this case, but that's probably true. So a judgment against my client for an easement across property he doesn't own is a pretty strange basis for a fee award under 1103. I also noticed today, as I was looking at the fee application, that the demand letter doesn't appear to have included a quitclaim deed, which is a clear requirement of the statute. I don't think that's been raised up to this point, but that's another significant defect in the proceedings and a reason why 1103 shouldn't have been applied. But yes, I do think it was argued that that there isn't a match, that you couldn't, as the Supreme Court said in the Pleak case, you couldn't get an easement relationship like this by tendering a quitclaim deed. If you quitclaimed all right, title, and interest, that would be completely different. That's what the Willises, the people back in 1956, originally tried to do. They wanted to not have responsibility for this road. My client is stuck paying taxes, potentially having tort liability, having all sorts of other liabilities associated with this road that he can't control. That is based on facts that are going on in other cases, primarily not in this case, but that's the consequences of the misjudgment in this case. I also want to make sure we don't overlook the fact that one of the parcels that the easement supposedly goes over is the 007 parcel, which is the parcel that doesn't go north and south, it goes east and west and has Mr. Berrey's house on it. And the judgment says that the easement goes over the entire length and width of his parcel, which is obviously wrong and needs to be corrected. And one of his neighbors has in fact threatened to bulldoze his house, so that's important.
So you believe that the easement is described incorrectly in the judgment?
It's clearly described incorrectly, and that's one of the other things that happened.
But if we disagree with you on the summary judgment argument, we could order that it be corrected to correctly reflect a 30-foot easement running lengthwise and not horizontal.
Yes, that would be the absolute minimum that you absolutely should do. It would be a grave injustice to leave the easement running over top of his house on the 007 parcel. Do you have any other questions about the preclusion issue? I think there are narrow grounds on which you can say that the judgment is not preclusive, and then you don't have to get into a collateral attack on that judgment as to whether it's void or not. That's in fact in front of the court, this court, in another case, because we asked for Rule 60 relief. And I think it's more proper for that court to decide whether the judgment was final and binding than this court. But are there any other questions about that situation?
Not that situation. So I want to make sure that I understand what you're asking of us. As far as Polly Berry not being included in the judgment, you believe that's an error as well?
No, that was resolved when we went back. It said
Okay.
Polly Berry is dismissed, no judgment against her or the marital community.
Excellent, that was not clear.
But that order that resulted in that is law of the case if you get into whether you need to name all the defendants in order to have a final judgment in the other case for purposes of preclusion analysis.
All right. So we need to correct the 007 lot.
We absolutely need to correct the 007 lot.
Okay. And we get back to this easement and going over the roadway. The way this is kind of characterized in this depiction that you provided us, which thank you for that, it was very helpful. It shows that the road does cross several places, but it also shows that the majority of it is completely on parcel 002. Is that what it's like on the actual property? Because we have statements from opposing counsel that it meanders back and forth.
Like other primitive roads, it's not perfectly straight as an arrow, but it is 98% over the property line. And the most detailed maps I've seen show that, even though they're not in the record here.
Is it asphalt or is it dirt?
Dirt.
Okay, I just wanted to make sure I understand so I can visualize what's going on.
And because of the judgment, because my client couldn't afford to bond over it, and because he already lost on appeal on the other one, neighboring landowners have already gone and bulldozed a road. So now, in fact, there are two roads that never existed before, and is a demonstration of the fact that it never existed before, because when they went in on this route, they were going up a different alignment.
Thank you.
Thank you. I'll reserve the rest of the time if I may.
You did under your defamation, I just wanted to ask a very
Sure.
simple question. Did you never presented any evidence of what was actually communicated to the third party?
It was Mr. Milliman's own statements in the phone call were the baseline evidence.
No, that was between them. I'm saying what was communicated to the third party?
Mr. Milliman said in the phone call to my client
That he had talked to the department.
that he had accused him
What
of
did he
fraud.
say to the department?
I don't think there are quotes, but he said he'd accused him of fraud, and I've
No,
called the
that's
department.
not what he said. He said, I've already alerted them. But if he says to the department, I think there may have been a fraud committed here and you need to investigate that, that is not defamation. That's a statement of opinion.
I think what he said is a question for the jury, taking into account all of the evidence.
Do you have any evidence about what was said?
I do not have a transcript or anything definitive like that.
Do you have any evidence of a complaint being filed?
It appears that the department did not start a complaint because it didn't qualify.
So you don't have anybody from the department that came in and said, yes, he called and this is what he communicated to me.
No, there were no such third-party witnesses.
Okay, thank you.
Good morning, Your Honors. My name is Timothy Barnes. I prefer Tim. I am counsel for Mr. Milliman and Milliman Investments. I was not, however, trial counsel. Mr. Arpaud describes it as odd. That's to say the least. This case has been around the block multiple times over a period of years.
It's got blocks named after it, doesn't it?
And what I found ironic as appeal counsel is that this all started from a letter in November of 2018 in which Scott Malm, who is quite a talented real estate attorney in his own right, brought before Mr. Berrey and his wife all of the issues, essentially all, not all of the issues, that's an overstatement, but he brought before them the fundamental issues in a fact and of law and quoted the Pleak case. Now, this was in November of 2018. He attached the 1956 deed as well as other documents. He even attached this court's 2019 case involving the flood control district. So I find it ironic that it started based on a letter which really spelled out, and that letter was attached as Exhibit A to the attorney's fees application that Mr. Milliman's trial counsel filed, which is, I believe, 249 in the record. Now, having said that,
Is that the basis for your request for attorney's fees? Is that letter?
it was attached, that letter was attached as an exhibit.
No.
No, I'm sorry, in the,
Is that your basis for attorney's fees under the quick claim
no,
statute?
no, it's not. It's not. If I may, Your Honor, I can't tell you why what was argued in the trial was argued. I just can't, and I wouldn't purport to because it would be outside of the record regardless. But what I can say is that the application was premised on 12-1103B. 12-1103B. Now, we know that Pleak says in a footnote, well, you can't really get them for that. But that was not raised by the plaintiff, by Mr. Berrey. I got confused.
Was there an actual quick claim deed that was communicated at the time?
Yes, in 1956. In 1956.
No, that's a quick claim deed.
And the $5.
Oh,
That was, because in order to get attorney's fees, you have to submit $5 and the actual what you want signed. And the way I understand it, and you can correct me if I'm wrong, that what was given is not correct. It's the same error that would be in this judgment, that it doesn't run through the home.
Your Honor, because that wasn't raised as an issue, I must say, I can't say, because I did not look and see.
All right. When I look at a quitclaim deed and what it's purporting to convey, it appears that the quitclaim deed with the $5 pursuant to the 1103B statutory entitlement would have, had Mr. Berrey signed it, conveyed a personal easement to McMillan, which is not what the Willises in 1954 actually quitclaimed. They quitclaimed a public dedication for street purposes. So if we read the statute, you send the quitclaim deed in order to avoid litigation and to make sure people, but in signing that deed, you're getting what you think you already own.
Right.
But that's not what was sent, was it?
I can't say what was sent because, again, Your Honor, I simply did not look. And of course, I'm kicking myself now, but
Well,
it wasn't raised.
if we look, and
Yes.
it doesn't, then the fees are out. Because, right? I mean, if it has to match. What you had has to match what you requested. And if it doesn't match, then litigation was fine and people bear their own fees.
Your Honor, it's rather difficult for me to debate the court.
Well, I was just asking you.
What the quitclaim deed says, conveyance of an easement to McMillan Investments and expressly, quote, for the benefit of McMillan Investments real property. So, will you just agree with me for the purpose of this argument that it tried to convey something specifically to your client, not to confirm a public easement?
Agreed.
Okay. And so if that is in fact the case, does 1103B still apply?
Well, first of all, that was the basis that was argued. there was no objection to that basis. In fact, what Mr. Berrey's argued in response was, well, and this was counsel, not Mr. Berrey himself. Mr. Berrey appeared pro se in a portion of it, but he had counsel at the end. But what Mr. Berrey's counsel argued in response to the motion for summary, in response to the application for attorney's fees included the suggestion that 12-1103B gives the court discretion, and the court should exercise its discretion in how much fees to award. So the argument that fees were owed under 12-1103B was accepted by Mr. Berrey's counsel, and therefore
accepted by the Superior Court.
And by the Superior Court as well.
But we're the court of error correction. So
I didn't see that on the logo. I'll take your word for it.
Can I quote the court?
well, if a statute is applied incorrectly, aren't we supposed to do something about it? I mean, isn't that our job?
Well, except that there are attorney's fees cases in which attorney's fees are sought under the statute, and they are awarded under the statute, even though the statute didn't apply. And this court and the Supreme Court has held, our Supreme Court has held, that if you don't make that objection, then you've waived your right to that objection, and the attorney's fees stand. So I don't think there's a get-out-of-jail-free card just because the statute may not apply. Because countervailing that is this notion that there somehow you've got to step up to the plate and say, no, wait a minute, you can't have the fees under that. And if you don't, then you've waived that argument.
And just for my information, the complaint asked for attorney's fees under two theories. One was contract and one was 1103. Is that correct?
That's my understanding of the complaint. I can't say that I've studied the complaint.
All right.
But you didn't make the contract argument in the fee application. I mean, when I say you, I'm talking about your client,
Yes.
not you.
Correct.
Personally.
That's correct, Your Honor. There was no argument made regarding the contract.
So if we find on review that there was no evidence to support the fee application under the quitclaim statutes, we don't need to remand for determination under contract because you didn't make that argument to the Superior Court.
Pardon me.
No, go ahead.
Again, I would respectfully submit to the court that if because the argument of the inapplicability of 12-1103 was not made at the trial court, then that argument I respectfully submit has been waived.
Okay.
In terms of some of the other arguments that counsel made, counsel suggested that because the reply, the trial counsel, Milliman trial counsel acknowledged, okay, there's $5,000 that we should knock it by. If you look at the fee application, it sought fees through July 19 of 2021, which means it did not seek fees for the period of time from July 20, 2021 to September 20, 2022, which was when the trial ended. So there was no request for fees there. Why, I simply don't know. But one suggestion I have is that the trial court may well have thought, well, you didn't ask for those. You're entitled to something for that because you did prevail, so I'm going to exercise my discretion and grant your fee request.
Yeah, I was going to say that's you don't get to do that.
I also wonder if you can give me your best case to support the waiver argument regarding the 1103. I find that fascinating. This isn't an aha moment.
No, I get that.
No. It just seems that we have to, if we're going to affirm a statutory award, there has to be something in the record that would support it. And you say, well, it's waiver. Well, okay, but we still have to find something in the record. And if you have a really good case that says, nope, it's waived, statutory requirements be damned, great, tell us. Because I didn't find one. That's why I'm asking.
There is a Supreme Court case that I looked at and kicked myself. I believe it's Trainer versus, begins with an F, and it was
Trainer
written
VF.
by,
We'll try to find it. And it's
Justice
specifically,
Feldman was still on the court, so I'm telling you, it was in the 90s. And
we refer to those cases as well established.
I'm well established, I like that.
But going back, was it a quitclaim deed?
no, that case had nothing to do with deeds. It had everything to do with arguing attorney's fees. That's what it had to do with, and the correct basis.
And I certainly get the notion that in a general request for attorney's fees, even under contract, you would have to make certain type of arguments because they're statutory and pretty discretionary. But for quitclaim deed fees, there's a statutory requirement that you have to do A, you have to do B, and you have to do, et cetera. And if the record doesn't support it, I wonder how we can turn a blind eye to it and affirm.
Judge, I understand the court's point. There's not much I can say in reply.
And that's a legitimate answer.
A couple other just random points that counsel made that I would like to address. Counsel takes umbrage with the width and length language in the final judgment. There was no objection to that language. There was no objection to the form of judgment that was submitted.
But you would agree with me that 007D with Mr. Berrey's house on it has nothing to do with the 30-foot dedicated public right-of-way.
Does not appear so.
Okay, and you would agree with me that is included in that judgment and needs to be removed.
Well, it's included because those were the three parcels that became from the original Lot 1. And that throughout the trial, it appears that people were talking about counsels, and Mr. Berrey initially on his own, were talking about those three parcels as a collective group. And I suspect that's why it's in the judgment.
But you would agree with me it needs to be corrected to get his parcel and house out of it.
I won't disagree.
All right.
Your Honors, unless the court had, on the defamation, I do want to comment on that. There's no evidence. There is zero evidence. No jury has a right to consider finding a defamation if, in fact, there's no evidence of what was said to the third party. And all it can try and glean is an inference, and that can't be reasonable because a reasonable inference has to be based upon facts that you can see and you heard, and that simply wasn't the case. So I respectfully submit that Mr. Berrey's argument on that point is not well taken. And without more questions, thank you very much.
Thank you, counsel.
If you have other questions for me, I'm happy to start with that.
Do you know of, I know you're an officer of the court and you'll tell me, can you waive an objection to a 1103 attorney's fee?
You should not. The doctrine of waiver has been applied harshly in some cases in Arizona. I don't know of any specifically applying to this type of an issue with 1103, but I absolutely agree you should apply the statute, and if it clearly doesn't cover, you shouldn't uphold the award of attorney's fees. And I think the record does establish that. That is one of the weirdest things about this case. When it started, Mr. Milliman was arguing that the county owned the road, and Mr. Berrey was arguing, no, I own the road. Now I think it's actually opposite. Mr. Berrey's in court, in the Superior Court, arguing actually there's new information, the county owns the road. And so it's extremely unlikely that any quitclaim deed issued at any time could have been executed and solved the problem.
But in failing to object to an award of fees, you've precluded McMillan from arguing that he's entitled to fees under contract, did you not?
The contract issue is an interesting one, and if it would help, I will go back and check and file something with the court just listing what I think happened, because now that I'm thinking about it, my memory is that there was a difference between the complaint and the amended complaint, and it may have been the amended complaint that didn't include 12-34101, which is the one he finally prevailed on.
But clearly in his application, he did not reference.
I don't believe that's in there at all, no.
So if he didn't reference the contract there, then he's abandoned.
I would agree with that, and I think that is a fair application of waiver. The last thing I'll say is that it is important, because this is going to continue no matter what you decide in this case, that we be careful about what it is we're deciding that right-of-way is, if the record establishes one. I don't think it does. I think it needs to go back to the trial court and be fleshed out. That's my argument. But if you decide that there's something there, please be careful in what you say it is. Please distinguish between a statutory dedication, which would be conveying a fee to an entity, which it seems to me is pretty clearly what the original quitclaim deed in 1956 was intended to do, and what ended up getting applied here, where in Pleak it said we're dedicating to the public an easement, and the common law dedication is an easement, and so there was a match there. That match doesn't exist here. What the trial court said existed is very different from what was ever offered.
And your time has run.
Thank you, Your Honor.
Thank you, counsel, for your arguments here today, for your patience with both of us. We will take this matter under advisement, issuing a written ruling in due course. We are adjourned.